Yes.
May I please, Lordship? Lordship, I beg to mention item number 16, Lordship. 16, Lordship. Lordship, if this matter may be listed after 3 weeks, Lordship.
How to say it?
No objection.
Learned Counsel for the appellant, Mr. L. Pom,
Lordship.
who makes a mention for listing the matter after 3 weeks. So the Learned Counsel for the respondent, Mr. Chubanakam, has no objections. List after 3 weeks.
Obliged, Lordship.
May I please, my lady? My
Yes.
lady, I beg to mention item number 14, my lady.
Yes.
With the other side's consent, may I beg to pay for listing it in the next week?
Next week.
Next week.
There is an IA for condonation of delay.
Yes, madam.
Are you filing any objections? You're appearing for the respondent, isn't it?
Yes, respond
Yes.
1 and 2.
Are you filing any objection to the condonation application?
There is no instruction from me right now.
Otherwise, 2 weeks. 2 weeks or next week?
Next week. Next week.
Learned Counsel for the petitioner, Mr. V. Devnath, who prays for listing the matter next week. So, Learned Counsel for the respondent, Mr. Seven is present. So, list next week.
Deeply ordered. Deeply ordered.
My pleasure, Chief. Allow pick the mention item number 1 on behalf of young order. Let this matter come out after a week.
My Lordship,
Item 1.
Yes.
my Lord, there is one aspect which I would beg this Honorable Court to consider. Because of this pending arbitration petition, my client cannot participate in new NITs, and it is becoming a problem for the firm of my client. So if this can be taken up urgently, it is more than a year since this petition has been filed.
What do they want to do, the union?
My Lord,
Are they not willing to refer it to arbitration?
Your Lordship, that instruction itself is not coming at all. It's about 2 months since we've been waiting for that instruction.
Oh, whether to refer or not? They haven't
Whether to
decided.
refer to the one arbitrator which can be agreed upon by both the parties or not, that instruction itself is not coming. Even a verbal instruction will do, my Lord.
Next week.
Yes, my Lord.
And tell him to get instructions. He need not file any affidavit or anything like that. This is an arbitration petition. The court has to just appoint
May I please?
an arbitrator suggested by the parties, that's all.
Oh, no, Your Lordship. There is some other development, Your Lordship.
What development?
Your Lordship, may kindly refer the order dated 23/10/2025.
Acha, that instruction standing SOP.
Yes.
Regardless,
No, but
Your Lordship.
that is issued only in 2025, isn't it?
Yes, Your Lordship. July.
And regardless of these executive instructions, the court can always appoint. This 22nd July 25.
Yes. Your Lordship, the last para 9.
Para 9.
Para 9, Your Lordship.
1.2.
No, Your Lordship, 23/10. Order 23/10, my Lord.
Oh, okay.
23/10/2025.
In view of this,
Yes, Your Lordship.
Okay, so the state respondents
Yes.
have to send the documents. That
Yes,
has been sent.
it has been sent, Your Lordship.
In
By
fact-
letter dated 11th of November 2025, if I may be allowed to place this on record, my Lord.
Your Lordship will kindly appreciate that this development will not disturb the proceedings, Your Lordship, because regardless of whether this instruction of 22nd July has come out or not, they are seized of the matter since last year.
Yes, this was filed in 24.
Yes, Your Lordship.
And notice had been received, I think.
Yes, Your Lordship.
Notice served on all the parties.
Notice has been
Yes.
served on all the
However,
parties.
the new SOP came and then this
So
Honorable
the
Court has...
union also knew that this
Yes.
petition was pending.
Yes, this Honorable Court has taken into consideration the new SOP, Your Lordship. And therefore, this order has been passed. Now, in compliance with this order, Your Lordship, we have already sent
basically, what do they say in the SOP?
Your Lordship, the SOP I have submitted on the last occasion.
Appointment will be made, state will apprise the union.
Union,
And the union will appoint the arbitrator if required. So they will take the steps.
No,
So
Your Lordship.
Union will appoint, that's the standing SOP. But here, in this proceeding, we have suggested the name of His Lordship, Justice Retired B.K. Sharma. So, my Lord, if the parties agree, then appointment can be done anytime.
Your Lordship, the SOP clearly states that.
And if the union appoints an arbitrator but the other party is not willing, then cannot be again. It has to be agreed upon by both the parties.
Yes,
Your Lordship, as far as the state is concerned, Your Lordship, whatever the union decide, we have got no objection to that, Your Lordship. Because the SOP says so.
What I mean is the petitioner.
Oh, that, yes,
Petitioner,
that-
yes, the petitioner may not agree to that arbitrator then. Because under section 11 of the Arbitration Act, it's the court who will appoint
My Lord.
on a
In the,
consensus.
yes, if at all a consensus arbitrator
yes,
cannot be appointed. Yes, correct, correct, my Lord.
Yes.
Correct, my Lord. But now we,
Actually, unnecessarily, I think it has been dragged on.
Your Lordship.
Next week, tell Mr. Yangarwati to obtain instructions. Need not be written instructions, even verbal instructions will do. Because by now, they must have received the papers from the
Lordship.
state government. Okay? The Learned Counsel for the petitioner, Mr. Joshua is present. Stop. Learned CGC, Mr. Z.N. Muli makes a prayer on behalf of Mr. Yangarwati, CGC, to list the matter after a week as he is yet to receive instruction. Stop. At this stage, the learned senior government advocate, Mr. N. Angami, submits that in compliance to order dated 23/10/2025 passed by this court, the state respondents have already sent all the relevant documents to the Union of India for their perusal and consideration. Stop. In view of such submission, list the matter after a week on the date to be. You want a specific date, or we'll say just 1 week? Okay.
After a week, Your Lordship.
After a week, on the date to be fixed by the registry, on which date the learned CGC shall place the instructions before this court, and if written instructions are not received, the verbal instructions will be submitted by the learned CGC. List after a week.
Obliged, Your Lordship.
My Lord, I beg to mention item number 2 also on the similar prayer, my Lord.
This also on behalf of Yangarwati.
Yes, my Lord.
These are non-negotiable matters.
Yes, to the tracking motion. In this case, the notice of motion was issued on 26/2024.
He is asking time for what?
My Lord,
Has he filed affidavit?
No, not yet.
no.
Not yet. I think this is regarding compensation.
Compensation.
Why are they taking so long?
Lordship, it was only last week. The state respondent had taken 1 week time for filing the affidavit.
But I think the union is the main party in this.
Union doesn't-
Third Learned Counsel, Mr. Z.N. Muli, who makes a mention on behalf of Mr. Yangarwati's Learned CGC, and submits that the affidavit on behalf of the Union of India has not been filed. And accordingly, he prays for
1 week, my Lord.
1 week.
1 week we will not do.
He has
Because,
received or not, that's the.
I'm not there yet,
If he has
received
received
instruction.
instruction, he can file within a week, but if not, then take 2 weeks.
2 weeks, Lordship.
List the matter
2
after
weeks.
2 weeks. 2 weeks in order to enable the respondents. Government also has not filed.
No,
In order to
the state doesn't yet
enable
file, Lordship.
the state respondents as well as the Union of India to file their affidavits. So, Learned Counsel for the petitioner, Mr. Limaropon, is present, as well as Mr. V. Zimomi for the state respondents. So, please, after 2 weeks. Yes.
But
Lordship, I beg to mention item number 25. Lordship, we are yet to file to the amended petition, Lordship. So, Lordship,
Amended petition.
Lordship.
When was it filed, the amended petition?
Last year.
Last year, then?
Lordship, I'm yet to receive instruction, Lordship, with regard to the amendment.
Okay, no objection, Your Worship. How much then?
2 weeks time.
Right, Learned Government Advocate Mr. V. Momi, who prays for 2 weeks' time to file a counter affidavit in the amended writ petition. Stop. Learned Counsel for the petitioner, Ms. Signatures are present and has no objection. List after 2 weeks. Yes.
Your Lordship, may I please, Your Lordship, I would like to mention item number 23 on behalf of SOP.
Yes.
Your Lordship, they have some personal difficulty today. If this matter can be passed over for tomorrow.
Learned Counsel, Ms. Signatures, submitting on behalf of Mr. A. Sophie, the leading counsel in this case, who has some difficulties today and accordingly prays for passing over the matter for the day. Pass over for the day. Yes.
Lordship, Lordship.
May I please, Lordship? My Lord, I beg to mention item number 26. My Lord, in the last occasion, by order dated 27/10/2025, his state was directed to obtain some instruction. However, I'm yet to receive that instruction. So kindly allow me 3 weeks time, my Lord.
3 weeks.
Yes, my Lord.
Learned Counsel for the petitioner, Ms. Signatures, the Learned Government Advocate, Mr. Tiba Pom, appearing on behalf of the state respondents, submits that this court had instructed the government advocate to obtain certain instructions. Which order? Which
By order dated 27/10/2025.
by order dated 27/10/2025, and he is yet to receive instructions in that matter. So accordingly, he prays for listing the matter after 3 weeks. So Learned Counsel for the petitioner has no objection. List after 3 weeks is prayed for. Yes.
Much obliged.
Please, Lordship. Lordship, I beg to mention item 15. Lordship, the arguing counsel have some personal difficulties today, so if it can be listed on 2nd December.
Learned Counsel, Mr. Signatures, who makes a mention on behalf of the leading counsel, who, Mr. Kezi?
T. Kezi.
Mr. T. Kezi, who has some difficulties today, and prays for listing the matter on 2/12/2025. So, Learned Counsel, Ms. Such and such, is present for the respondents and has no objection. So, list on 2/12. Yes.
Obliged.
May I please, my Lord? My Lord, I beg to mention item 18.
Your Ladyship, I'm opposing the adjournment. This is a matter in which, with consent, dates are taken. It is well known to the other side that I am coming from Delhi. And then at the last minute on each hearing, the order sheets reflect that, an adjournment is sought. Once I was told there is somebody has, and on each occasion I have been very cordial and I have accommodated, because if a colleague makes, nobody at the bar ever declines. But now it's beginning to become a little inconvenient. They have filed, this is the case, Your Ladyship is aware, one of the earliest orders was passed by this court, where
Yes, I remember.
I'm grateful. Your Ladyship, the mere subsistence of this matter, we all know what impact this has. This court has enough experience. There is no stay in their favor. In fact, on the last hearing, it was clarified by this honorable court that there is no stay operating. There is now a trial.
Trial is going on.
Trial has to commence. It is not yet started because on an earlier date, they used the presence of this petition to just mislead the court. Therefore, we secured a clarification from this court on the last date that there is no stay operating. Because when a petition of this nature is filed, it has ramifications beyond the immediate order. There is no reason why this charge sheet or FIR will be quashed by this court, as per the law laid down by the Supreme Court. However, the accused is a public servant who holding a high office, presently under suspension. The women, most of whom no longer even hold those jobs because their contracts have all been have expired and have not been renewed. The structural power imbalance is writ large in this case. Not only will it have an impact on the presence of this on the trial, because there's a delayed drag motion which has now been...
Even charge has not been framed.
No, charges have
Your
not been
Ladyship,
framed.
it's fixed on 26.
They secured a long date last time.
Lordship.
Sorry?
26.
26th is for appearance, not for framing of charge. Kindly look up the order. I have looked up all the orders before coming to court. Your Lordship.
Because we have not
just
obtained
one
all the
minute.
documents,
Your
Lordship.
Because
We have not received all the documents. We
it
have
is
prayed
not
for
for
it.
207. 207 stage is over.
Oh, you mean for framing of charge?
Lordship.
No, but of course that has nothing to do with this case.
Yes.
Your Ladyship, only two things.
No,
One,
why are you seeking adjournment?
Your Ladyship, my senior actually, he has developed a severe dust allergy, which he had to undergo for treatment
I
at
come from Delhi.
Gauhati.
There can be no worse dust allergy
Ladyship,
than in Delhi. And
I've-
I'm loving the cleanliness of the Kohima air. Yesterday
Of course
evening, I
we're
went for a
blessed with
walk.
that.
Yesterday evening, I went for a walk and I sent there is a little board here which tells you the pollution levels of
Yes,
Kohima.
yes.
I sent that picture to my 90-year-old mother. And she said to me, breathe, do deep breathing while you're in Kohima. You cannot have an allergy in Kohima. I come from Delhi. It is toxic air we are breathing. So thank you for giving me the opportunity to breathe
talk
clean
about
air.
the air.
Your Ladyship, one last submission, because I think one needs to understand why these
No,
kind
no,
of...
these
look
kind
at
of
the- look at the
petitions
respondents.
need to be disposed early.
I'm very
Ladyship,
grateful.
Ladyship.
Your Ladyship will just look at the respondents. I represent respondents 5 to 8. 5, 6, 7 are members of the Nagaland State Women's Commission. From the beginning, I've been saying these are not necessary parties. Respondent number 8 is the commission. That is the necessary party. This is done to harass and then to intimidate and silence everyone. We all know these tricks. So either this matter is heard and disposed of, the minimum at least delete 5 to 7. You cannot file this and then...
Can he appear tomorrow?
Ladyship, I don't think so. He has some problem, which he is still under medication. So it is a humble prayer, and with due respect to our madam also, I've already informed our opposite counsel.
Yesterday, when the flight had already
from
come.
last week. I don't want to even trouble our senior. So
No, I'm already troubled, I'm here.
They're coming all the way from there.
yes, Ladyship. And also, we have received the affidavit in opposition for respondents 6, 7, and 8 only this morning.
They are identical to 5, you already have 5. There is
So
no
I may be
difference.
given a short date to file my reply to this also.
No, the date was given earlier. Let's see the last order.
Can I
Your
see
Ladyship, there has to be an end to this now. Please see the order dated 7th October. They have dragged this case
No,
from
no,
April.
I understand what you're saying, there is urgency, but again, there is senior's problem, that is also,
On each occasion, let them engage a different senior. There must be others who can be arguing counsels in Kohima High Court. They can't hold a case to ransom like this. Your Ladyship, the last order is dated 7th October.
yes.
Your Ladyship may kindly see where they were asked to file their petitioners had earlier sought time. The second paragraph, in fact, details that. They sought further 2 weeks for filing rejoinder affidavit to the affidavit in opposition. Petitioners had earlier sought time on 22nd May, 22nd July. Also submitted amended petition has been filed and served. I sought 2 weeks, I have filed in 2 weeks, it's identical, there is no difference. You have mine for R5 already. Respondents may file by 30th, I filed it on 30th. The rejoinder affidavit by the petitioner to be filed within 2 weeks. Thereafter, 2 weeks starting 30th October. We are now end of November. If no affidavit in opposition is filed by respondents by 30th October, the petitioner may file to the earlier one on record, so that there is no further delay. List the matter again on such and such date. It is observed that this court had earlier noted the submission that the prayer for stay of investigation had become infructuous on the submission of charge sheet. It is also observed that there is no stay operating in the proceedings before the trial court as of today. I had sought this clarification because a misrepresentation was made to the trial court. That is how subliminally a matter is pending. We have impleaded, all the members are now facing a quashing. We know how this is used outside and inside the courtroom.
Your Ladyship, then in that
We'll
case,
put it next week.
10 days may be given, Lord Ladyship.
And on
because-
the next date, if your senior is still unwell, you engage somebody else.
Yes, Ladyship.
Okay, that
Yes.
cannot be an excuse on the next
Right.
date.
At least minimum 10 days may be given, Ladyship, so that,
10 days?
Yes, madam. What would be a convenient date for you?
He's seeking 10 days, I think.
He's seeking 10 days, but it's up to you because
The dust allergy,
Since
I'm
you
sure
are
he will
coming-
recover. He'll be in court tomorrow morning. No. I'm leaving today, don't worry. Your ladyship is giving what date? Because the court is, I think, closing for vacation
we are
also.
closing on last working day is 12th of December.
12th of December.
Yes.
I've just got a date from Uttarakhand from 9th, I think. Can it be 11th then? Because 12th being a last working date may be a little difficult. Would I have kind of friends here who are suggesting to me that I should come when there are other things also happening in the city. Some colleagues are very kind, which is a special
I
time
think
for
I
this.
can guess what other things.
Would 10th be convenient? 10th is?
10th.
DBD. All right. Then we can keep it for 11th, I would imagine. I'm just, just give me, your ladyship will just give me half a minute because we've just got.
No, even if it's a DB day, a single bench also can be constituted. That's not a problem.
if there's no problem for Ladyship then.
Then if it can be 10th or 9th,
Okay, 9th. 9th would be best, I think.
9th, please, your ladyship. I'm very grateful. Your ladyship may note in the order that it will be for arguments.
Yes. Donor counsel for the petitioner, Mr.
V. Kozar,
V.
Ladyship.
Koza, has made a prayer for adjournment of the matter for 10 days on the ground that his senior, Mr. A. Zo,
Lordship.
is indisposed. Stop. The prayer is objected to by the learned counsel for the respondents 5, 6, 7 and 8, Ms. Vrinda Grover, on the ground that several adjournments have already been granted to the petitioners earlier on 22/5/25, 22/7/25 and 7/10/2025. Stop. The court, by order dated 7/10/2025, has also directed that if no affidavit in opposition is filed, that is for you.
Yes, after
You
that
have
is,
already filed.
I have filed.
Okay.
And 2 weeks to them
delete
after that.
Yes. The affidavit in opposition has already been filed by the respondents. However, the rejoinder affidavit by the petitioner has not been filed, even after the 2 weeks which has been given to the petitioners to file their rejoinder affidavit. Stop. As a last opportunity, list the matter on 9th December 2025, on which date the matter will be taken up for admission hearing, and in the event that the leading counsel is still indisposed, the petitioner shall make arrangements for engaging another counsel.
I'm very grateful.
Stop.
Much
Yes,
obliged.
list on 9th.
Please, your ladyship.
Much obliged.
Oh, I think my cost list is also there. Koza, my cost list. Cost list is.
For addition, item number 17.
Lordship, Lordship, I received an instruction. Lordship, I received an instruction that.
Acha, has the petitioner given his statement to the IO? Has he met the IO?
Yes, madam. The petitioner have given his statement.
Let's see.
What happened is that, Your Lordship, here in this case, when we make a contact, IO has already been transferred, and this status report has been given by the OC.
Oh. His name is
Darapal. Your Lordship, para 5 will be relevant. It's registered in the name of Kidu Lana. And this person has actually sold out to the petitioner.
Acha, can the original owner give an undertaking or affidavit?
Yes, my lord, I've annexed
saying that he
in my
has sold?
petition.
Where is it?
On page 36. An extra 8.
Okay, we will note that because in fact, the IO has examined the other original
Yes,
buyer,
the original
seller also.
original owner also.
Lord Learned Counsel for the petitioner, Mr. Pakling Chapun, also heard Ms. Levika Leonard PP for the state of Nagaland. Stop para. The present application has been filed under section 497 and 503 of the BNSS, read with section 438, 442 and 528 of the BNSS, praying for release of the seized Maruti Gypsy vehicle bearing registration number MN03P8720 on Zima, pending disposal of the Kozama disposal of a special case number 17/2025 arising out of Kozama PS case number 6/2025 registered under section 22C NDPS Act, read with section 3 clause 5 BNS. Stop. The Learned Counsel for the petitioner submits that on 25/6/2025, during checking at the interstate check gate Kusama, the police personnel on duty had arrested 2 persons on alleged recovery of illegal drugs. Stop. Accordingly, the vehicle bearing registration number MN03P8720 was seized and kept in the Kusama police station in connection with the above mentioned case. Stop. The petitioner states that he is the rightful owner of the seized vehicle as he had purchased the same from his friend Shri Kiddu Kidu Lanah, Kiddu Lana, who is the registered owner in the RC. Stop. The petitioner states that he is innocent and has nothing to do with the aforementioned special case number 17/2025 arising out of Kozama PS case 6 of 2025. Stop. He also states that he had executed a sale deed dated 27/5/2025 and the possession was transferred to him. Stop. Thereafter, the registered owner has also declared on affidavit dated 23/9 date of the affidavit. 23/9/2025 stating that he had sold the vehicle to the present petitioner, white sale deed dated 27/5/2025, and stating that he has no objection in regard to the present owner transferring the registration certificate into his name. Stop. However, before the petitioner could take steps to transfer the ownership of the vehicle in the concerned district transport office due to law and order situation in Manipur and shifting of the concerned DTO office from Kangpokpi to Imphal, his vehicle was seized in connection with the incident case. Stop. Para. The petitioner submits that he had already filed a Zima application before the special court and the same was dismissed by order dated 23/7/2025.
3/10/2025.
23/7. Isn't it 23/7?
No, Jima disposed order is 3/10/2025. And it's 3 page 20.
Okay, and the same was dismissed by order dated 3/10/2025. On what ground? On the ground that the certification of registration was not transferred in the name of the applicant except for the sale deed entered into between the applicant and the owner of the vehicle, which is not sufficient to claim ownership in the eye of law. Stop. We just continue. Being aggrieved, the petitioner is before this court, praying for release of his seized vehicle, Maruti Gypsy, bearing registration number such and such, and Zima. Stop. Also heard learned PP, Ms. Livika, for the state respondents. Stop. The learned PP has produced a status report from the OC of Kohima PS dated 22/11/2025. Stop. Upon going through the same, it is seen that the present petitioner had given his statement before the IO, who had verified the sale deed and found that he had bought the vehicle on 27th May 2025 for an amount of Rs 4.5 lakhs, and the sale deed had been registered and authenticated by the Oath Commissioner, Judicial, Senapati, Manipur. Stop. Further, the IO had also contacted the registered owner / Mr. Kidu Lana, KIDULANH, Kidu Lana, who also confirmed that he was the registered owner of the vehicle and that he had sold his vehicle to the present petitioner on execution of sale deed registered and authenticated by the Oath Commissioner, Judicial, Senapati, Manipur. This court is of the view that ownership can be established through ownership of a vehicle can be established through a sale deed, through payment receipts, through an affidavit by the seller, and by physical possession prior to the seizure. Stop. The registration certificate is only one mode of proving the ownership. Stop. In this present case, the petitioner / owner has already given his statement before the IO, and the original owner, whose name is reflected in the registration certificate, has also given his statement before the IO to the effect that he has already sold the vehicle to the present petitioner. Stop. The affidavit sworn by the original owner, Mr. Kidu Lana, is also on record as Annexure 8 to the petition. So, this court is therefore of the view that the present petition can be allowed at this stage. So, accordingly, the seized vehicle Maruti Gypsy bearing registration number MN03P8720 is released to the petitioner on Zima pending disposal of the special case number 17/2025 on the following terms and conditions. Number 1, the petitioner shall execute a Zima bond of rupees 40,000 and thereafter the IO shall not the IO,
Yeah,
the
right now
OC,
it's
and
OC.
thereafter the OC shall release the same to the petitioner. Stop. Number 2, the petitioner shall not change the appearance of the vehicle or change the color appearance / color of the vehicle in any way, and shall not dispose of the same during the pendency of the case. Stop. Number 3, the petitioner shall produce the vehicle before the IO or the court if directed to do so. Stop. With the above directions, the petition is disposed.
For admission, item number 19.
Koza, the results, the reports are here. Reports. Let's see. Acha. In this case, it's already charge sheeted, and then and I think CC is fixed or already charge also framed, isn't it?
Yes. Yeah.
Charge also framed on 23/9, and then evidence has started on 12/11. 12/11, and more pertinent is that two co-accused were released on interim bail on medical ground. One on medical ground and one because of the death of his mother. Then the other two were released because the court felt that the trial is going to take a long time. So I think parity on ground of
Parity, Your Ladyship, here parity cannot be a ground because their role are
Why not?
distinct. Their role are distinct. If Your Ladyship would see the additional supplementary charge sheet, the present accused, he is directly involved in the offense. The offense, the involvement is larger. If Your Ladyship will see the supplementary charge sheet. Point 4. The role of the present accused. Supplementary charge sheet is a part of the petition itself. At page 28. Yes, yes. If Your Ladyship will see at page 28.
Yes.
Point 4. During the course of investigation, the following person, A. Nimcha Hoikip, Nailam Hoikip, Lam Nailal Hoikip, and Lekha Hoikip. Lekha Hoi is the present petitioner, were seen to be involved and linked to a larger drug racket, and their whereabouts were traced to Kankopi and Mokban area in Kankopi district, Manipur. Efforts were made to catch the persons, however, further action could not be initiated due to the prevailing traces in Manipur. In this regard, a letter dated so-and-so was written to SP Kankopi, Manipur to apprehend the aforementioned person. Non-bailable warrant of arrest was issued by the Honorable Special Court Kohima against the accused, namely serial number 4 is the present accused. Now, coming to point number 9, the statement, the admission of the accused.
9.
Yes, point number 9, page 2. The statement of the accused A.V. Lekha Hoikip was recorded on 23/3/2025 at PS Terminal, and he stated as follows. The accused A.V. Lekha Hoikip admitted he gave the 20 sub-cases of suspected drugs sunflower to the accused Matthew S.H. on 12/2/24. Then coming to point number C. The accused A.V. Lekha Hoikip stated that on 12/2/2024, the accused A.V. Lekha Hoikip hired an auto rickshaw and went and gave the 20 sub-cases of suspected drugs sunflower to the accused Matthew S.H. at his house at Senapati, and on 12/2/24, the accused Matthew S.H. then gave the accused A.V. Lekha Hoikip rupees to 1 lakh. So this is the admitted position of the accused. Then your ladyship, coming to point 9, subpoint F, page 3. The accused A.V. Lekha Hoikip also admitted that he provided 40 sub-cases of suspected drugs sunflower to the accused Matthew S.H. in the year 2022. The accused A.V. Lekha Hoikip stated that he gave the 20 sub-cases of suspected sunflower to the accused Matthew S.H. on 12/2/2024, and the accused A. Hoikip also stated that the accused person, Nimcha Hoikip, Nalim Hoikip, Lamnain Lal Hoikip, were not involved in the incident on 12/2/2024. The accused A.V. Lekha Hoikip stated that he does not know the whereabouts of the accused person. So, Your Ladyship, this all shows that he has a direct involvement in the offense. Now, coming to page 4. Page 4, point 13, subpoint D. Page 4, subpoint D. In 2022, Lekha Hoikip supplied him with consignment of 30 to 40 sub-cases of heroin sunflower at rupees 10,500 per sub-cases. The price varied depending on the availability of the items. Now coming to point 14. On 23/5/2024, the expert opinion report was received from FSL Dimapur, right letter dated so-and-so. The analyst report confirms that the exhibits marked as C1388/2024 on the test were found to be distilled morphine, heroin. So, Your Ladyship, this has confirmed the item seized. Now coming to point 18, page 5. Further, from the above the physical evidence, the accused person's statement and admissions, witness accounts, supply routes, mode of conveyance, CDR, analyst report, seized item, and FSL analyst report, it is proven beyond reasonable doubt that accused Lekha Hoikip was found involved in the instant case. So, Your Ladyship, the involvement, the role is distinct from the other co-accused, and the accused should not be granted bail at this stage. There is a clear material found against the accused.
The other co-accused, how were they connected?
They are co-passenger. The one co-accused who got the bail, and the petitioner has annexed it at page, annexer 11, page 44, Rajesh Singh. The petitioner is claiming that his role is similar with this co-accused, but it is not. Their role is distinct. It could be clearly found from the supplementary charge sheet. Rajesh was arrested on the day itself, whereas Hoikip was absconding. He was evading arrest. So that also one ground. And then the commercial quantity, it involves a commercial quantity attracting the rigor of 37 NDPS. So,
then what about those, then I found another Ananda, Saikya, and then Deepak, something.
No, those are not annexed here.
No, in the
maybe in the record, yes.
There are many of them. There are many Rajesh Singh and Debojit Chetty.
Yes, Rajesh Singh is just a co-accused. Co-passenger. He has no role in financing, sourcing. Whereas the present accused is the principal supplier. He is linked to interstate drug networking racket. That is admitted by the accused himself.
Okay, yes. What is your other ground besides verity?
Madam, I am also supporting what my Leonard PP has stated, that please, if you kindly take, my Leonard PP is not taking you to the first charge sheet. The first charge sheet. What actually you must appreciate that she's also supporting my case because they were also released under Section 27A, 29 NDPS Act. They were released not under any other act, your leadership. The first charge sheet. The charges are the same against the accused persons and the other accused persons.
Have you annexed the first charge sheet also?
No, my lady, no. But I have it with me. Here.
It is
If we
over
can quickly
but-
see from here, then. Here. This is my copy.
It is here, it is here.
We deposit Saigya. I'm in the same boat with if alleged in page number, the second last page, B, Mr. Deposit Saigya.
One Rajesh Singh drives a commercial vehicle. That is different. Rajesh Singh is they are the vehicle drivers. This Rajesh Singh and Ananda Saikya, they are drivers.
My lady, please come to page
Then
number
Debojit
para
Saikya,
26. If you come to para 26, how the IO has found that his investigation.
Yes.
Para 26. Under section 21C, rate with 34, is one will establish against the accused Ananda Saigya and number 2, Rajesh Singh, for involved in possession, selling, purchasing, transporting, importing, exporting interstate of commercial quantity of manufactured drug. That's heroin. Huh? And number P, that's where I'm also charged similarly. Whereas a prima facie case under section 21C, 27A, 29 NDPS Act is found well established against accused Debojit Chetia, who was released on 28/4 this year to 28/4/2025 by the same honorable court, by the lower court. The sections against me are not any other sections. I am also found charged under NDPS, similarly as the other accused persons. Lady.
See, all this Debojit Chetya and then Rajesh and Ananda and all, they are the carriers. They have bought from this one Matthew.
Yes.
Okay.
Yes.
And this Matthew is absconding, and Matthew is the one who used to get it from this present accused. Let's go how
Yes.
who is the main supplier.
Yes. There are 4 persons named here, not only him, there are 4 persons named here. My lady, if I will take you, then that will be decided during trial. And the supplementary charge sheet, the police have filed, which my lady, my Leonard PP has also read out before you. He has also stated that in para 9, in supplementary charge sheet, the statement of the accused 5, Likaho, was recorded on 23rd, and he stated as follows, madam. My Leonard PP has read it out that the accused admitted that he gave 20 soap cases of suspected drug sunflower to the accused Matthew on so-and-so date. The accused Likaho stated that the driver of the moment was driving a gypsy vehicle, approached the accused Likaho at Bazar on so-and-so, and cases of suspected drug sunflower on 12/2/2024. The accused AV Likaho Outgrip also stated that he does not know the identity and whereabouts about the driver, Mr. Bowman. The accused Likaho Outgrip stated that he does not know the number plates of the gypsy vehicle. Madam, those statements are made before the police. And the Honorable Court, and even in the Act, the Evidence Act, the CRPC also has clearly stated that the statement before the police is not an evidence before the Honorable Court. It will be proved during trial, Your Lady. The judgment, I will place it before you. Madam Gipadu, please.
How many witnesses are there in this case?
Your Ladyship,
15 witnesses are here, Your Lady. On the first date, 2 witnesses were called. But the accused persons who were released on bail did not turn up. And on inquiry of the learned counsel of the accused persons who turned up, it seems he was not well. He was not in the station and was not well. So the deposition, the witnesses who turned up could not be disposed of on the said day, Your Ladyship. It will take a long time. And the learned special public prosecutor has also stated that they will add more witnesses in the course of trial. And if I'm kept under custody here, before even I'm convicted for a long period of time.
What do you want to show from here?
Oh, my lady, that
Yes.
the charge sheet has been filed by the investigating officer, by the IO, on the basing on the statement of the accused while in the custody, which has been read out by my learned PP. So I want to read out this para number.
Regarding statement in custody.
Yes, statement in custody.
That is, of course.
Yes, exactly. So this charge sheet filed by the officers, by the police officers, are the statements while in the custody. Whereas the accused person does not know any of the persons who were arrested earlier. He was arrested only on the statement of some arrested persons who were in custody, and he does not know them.
But what about the fact that you were evading arrest?
No, Your Lady.
For a long time.
No, Your Lady, it's not like that. Please come to my paragraph number, my starting petition. Paragraph, page number 3. Paragraph 3. There's no question of evading arrest here, Your Lady. Page, I'll read it out for you, Your Lady. That the petitioner begs to state that the alleged accused was asked to come by the Kangkupi police on 2 occasions. As such, despite of his works in the village, as a citizen and law-abiding citizen, the alleged accused person in good faith appeared before the police on both the occasions. However, on 2 occasions, Your Lady, however, to his shock and dismay, he was arrested on the second occasion on 23/2025 in Kangkupi PS in connection with this case, where in connection with so-and-so, later registered as so-and-so, where 2 accused persons, namely Rajesh Singh and Anatan Sagya of Kolagat, Assam, were arrested at the first place. That further, I will continue. That no illegal substances were seized from the possession of the alleged accused at the time of his arrest, but solely arrested on the basis of further investigation by the investigation officer. He was not arrested from the village also. He was not arrested from his house also. First, he was called to the Kangkupi police station. In March, he went. On the day he was called, despite of the warrant, maybe they did not arrest him because he was abiding citizen. So on the first occasion, he went to the Kangkupi police station. He was not arrested. He was allowed to go to his village. Again, on the second occasion, in March and April, he was called. Then, on the time only, he was arrested, Your Lady. He never evaded arrest. That shows that he is a good citizen, he is a law-abiding citizen. And on both the occasions, in good faith, he went to the police stations from his village. So he has never evaded arrest, Your Lady.
Anything was recovered from his possession?
Nothing, no, nothing. And all the 4 persons who were arrested here, he does not know any one of them. He is a businessman by profession. He is a workshop carriage, and he does timber business. There are transactions in his small transactions in his account. For those transactions, which were alleged to have transacted with some of the accused persons, he was arrested, Your Lady. And the statements given here in the supplementary charge sheet are made before the police, which is not admissible unless proof after trial. under the same sections already, the others have been released on bail. I'm not been booked under some other BOXO or UAP or some other IPC sections. I also have been booked under the same sections.
Acha, have you enclosed the bail orders of the
Yes.
deposit and
Yes.
the son?
Oh.
Because
Madam, please come to this.
Because
Page number
Matthew
44.
and Ananda, they were allowed interim on different grounds. One was medical ground and one was because of the demise of his mother.
Yes, and please come to page number
So
44.
the others,
Rajesh Singh.
no, not just Rajesh Singh.
Madam, page number.
This is the one.
Yes.
Rajat Singh and Debojit.
Yes.
Yes. Okay. Heard Learned Counsel for the petitioner, Mr. Alamapa. Also heard Ms. S. Mary Learned Public Prosecutor for the state. The trial court reports have also been received and perused. This present application under Section 483 of the BNSS has been filed praying for the release of the alleged accused Mr. Letko Haukip, Letkhohao, Haukip on bail, pending disposal of the special case number 5/2024 arising out of Tsiminu BS case number 003/2024 under section 21 clause C NDPS Act read with section 34 BNS. Stop. The Learned Counsel for the petitioner submits that the accused was arrested on 23/2025 at Kangpokpi PS in connection with the instant case. So, it is stated that the accused was asked to appear before the Kangpokpi police station on 2 occasions, and as such, being a law-abiding citizen, the accused in good faith appeared before the police on both the occasions. However, he was arrested on the second occasion on 23/2025 at the Kangpokpi police station. It is stated that no illegal substances were seized from the possession of the alleged accused at the time of arrest, and no recovery was made from him. His name is also not mentioned in the FIR, and there is no concrete material linking the alleged accused person to the seized contraband in the instant case. He was also not apprehended from the scene, from the place where the recovery was made, nor was any contraband substance, nor was he found in conscious possession of any contraband substance at the time of his arrest. It is further stated that the bank statements of the alleged accused also clearly indicates that he has no incriminating transaction history with any of the co-accused in the instant case. The further submission of the Learned Counsel for the petitioner is that the accused does not know any of the other co-accused, and he has been charged and arrested in the present case only on the basis of statements made by the co-accused before the police during investigation, and also on the basis of his statements made during investigation before the police, which are not admissible in evidence. So, besides that, there is no other material to link the present alleged accused to the instant case. So, another submission of the learned counsel for the petitioner is that there are around 15 witnesses, and the prosecution has prayed for time to produce additional witnesses in the course of the trial. So, in the present case, the charge sheet has already been submitted, and charge was framed against the accused on 23/9/2025, and the trial is at the initial stage. Stop. It is also stated that the present alleged accused is liable to be released on bail on the ground of parity, inasmuch as the co-accused have already been released on bail by various orders of the learned trial court. And among them, the order dated 28/4/2025 in IA 31/2025 has been annexed in the petition, by which two co-accused, Rajesh Singh and Debojit Chetia, Debojit Chetia, Chetia, have been released on bail by the trial court by order dated 28/4/2025, on the ground that the trial will take time. On the ground that the trial will take time. So, it is stated that the co-accused Rajesh Singh and Debojit Saikia were also charge sheeted under the same sections, i.e. Section 21, Clause C, NTPS Act, and what were the other sections? And Section 27A/29 of the NTPS Act, read with Section 34 IPC. So, however, they have already been released on bail on 28/4/2025. So, learned counsel for the petitioner therefore submits that even on the ground of parity, the alleged accused is entitled to be released on bail. Stop. Learned public prosecutor, Ms. Esmeri, appearing for the state respondent, has vehemently objected to the present bail application on the ground that the present accused is the main supplier in the instant case, and as per the supplementary charge sheet, it can be easily understood that it was the present alleged accused who had been supplying the contraband substances to one Mr. Who was that? One co-accused, Matthew S.H. on different occasions, starting from 2024. No, from 2024 to 25, isn't it? Yes. No, 22.
To 22, yes.
Starting from 2022 to 2025. Stop. It is stated that the co-accused Matthew S.H. had been granted bail by the trial court on the ground that his mother,
Bereavement.
on the ground of bereavement, as his mother had passed away when he was in custody. Stop. And it is pertinent that the said co-accused has been absconding since he was granted bail, since the time he was granted bail, and has not appeared before the trial court till date. Stop. It is submitted that in the event the present alleged accused is released on bail, he will continue to indulge in similar offences and is liable to abscond. Stop. She therefore submits that the present application may be dismissed. Before that, you just say, learned PP submits that since the present alleged accused is the main accused in the case, the other co-accused is the main accused in the present case, the ground of parity does not arise, as the other co-accused are merely suppliers, are merely carriers and not the main supplier. Stop. And then after that you say that appraise that it may be dismissed. No? The court has considered the submission of the counsel for the parties and also produced the trial court reports. Stop. Upon going through the same, it is seen that the petitioner, the alleged accused, has been arrested on 23/2025. Stop. The charge had been framed against him on 23/9/2025, and the evidence has already started on 12/11/2025. Admittedly, the co-accused Rajesh Singh and Debojit Chetya were released on bail on the ground that submission of the supplementary charge sheet would take time. Stop. However, as on date, it is seen that the supplementary charge sheet has already been filed and the trial has commenced. Stop. This court is also of the view that PWs, that examination of 15 PWs would not take an inordinately long time. Since the trial has already commenced, this court is of the view that the trial court shall expedite the trial. However, the present petition is dismissed at this stage.
My lady.
You try again after some time. Okay, if the trial still prolongs, then maybe the court will allow.
Then may I,
At this stage, we cannot say that the trial will take a long time. Okay.
because
And regarding that evidence that it not admissible and all that, at this
Those are not
stage we
relevant.
cannot go into it in
Yes.
bail. That is up to the trial.
Actually,
court.
Your Lady, it's okay,
Yes.
since it's passed, but I have also annexed one medical ground also. If,
Here.
yes, in here, nah, one medical ground, so I have added in my paragraph.
That will
No,
not be a new ground, because on
didn't
earlier occasion also it has been rejected on medical ground. If your
The
ladyship,
same
yes,
accused.
yes, same accused, so there is no change in circumstances.
Yes, I think you had
Yes.
approached this court earlier
Yes,
on
yes,
medical
that
grounds.
is annexed, yes.
Madam, 11, Bara 11.
Jail authorities are, yes, this is the one.
Yes.
Jail authorities are directed to
Yes.
give proper medical attention and to produce him before an HAK. Has he been taken for the CT scan?
No, Your Lady.
Then you, for that you come again?
Yes.
Yes.
Okay.
For orders, item number 20.
Please, Your Ladyship. Ladyship, I'm appearing for respondents 1, 2, and 3. The appellants are yet to submit the copies of the IA. So if
Alright. Direction was there on 6/11 also to give you copy, isn't it? Where the appellant? No one appears.
they usually appear through VC.
Learned Counsel, Mr. Nomusa appears for the respondents. Stop. Which respondents? 1, 2, and 3?
1, 2, and 3.
Respondents 1, 2, and 3. Stop. None appears for the appellant when the matter is called. Stop. On 6/11/2025, this court had directed the applicant/appellant to serve copy of the IA 17 of 2025 on the Learned Counsel for the respondents within 1 week from the date of the order. Stop. However, it is submitted by the Learned Counsel for the respondent that the same has not been served. Stop. Accordingly, the applicants are directed to serve copy of the IA 17 of 2025 on the Learned Counsel for the respondents within 1 week.
For orders, item number 21.
Your Lordship, steps that taken to the respondents kindly grant us 2 weeks time.
Respondent, which respondent? Oh, you have not taken steps. You have not taken steps, isn't it?
We have taken steps through speed post.
Then nothing is reflected. Order Office Note 1911 says steps not taken for service of notice upon the respondents. You just clarify, okay? Learned Counsel for the petitioner and such and such present. Stop. The Office Note dated 19/11/2025 indicates that the petitioner has not taken steps for service of notice upon the respondents. Stop. The petitioner shall do the needful and to take steps for service of notice upon the respondents and list the matter after 2 weeks.
Similar prayer for 22.
You just check up from the registry, okay? Because the note says you have not taken steps. Yes.
For
Same
all-
order in item 22.
Yes.
Item 22, same order.
For orders, item number 24.
My Ladyship, the IA is for implement of the Secretary to the Department of Higher and Technical Education, Srimati Sarita Yadav.
Yes, R4.
Yes.
Learned Counsel for the petitioner, Mr. N. Longkumar. Stop. The present application has been filed praying for implement of Srimati Sarita Yadav, IS Secretary, Government of Nagaland, Department of Higher and Technical Education as respondent number 4 in the connected in the connected contempt petition 21 of 2023. Stop. Para. The learned counsel for the petitioner submits that during the pendency of the COP 21 of 2023, what happened during the pendency?
Actually, we found it necessary to implement the chief secretary because necessary orders were required to be passed for constitution of district level verification committee.
Oh,
However,
Yes,
since the
yes,
chief secretary is the head of the state, it was felt that the necessary party will be the secretary.
During the pendency, it has been found that the Secretary of Higher and Technical Education would be a necessary party in the connected COP 21 of 2023. It is therefore prayed that that Srimati Sarita Yadav IS, Secretary to the Government of Nagaland, Department of Higher and Technical Education, may be implemented as respondent number 4 in COP number 21/2023. Stop. I think that will solve the problem, isn't it?
Yes. My lady, it seems there's a typing error. It should be respondent number 3. Because three was not implemented, it was withdrawn.
Okay.
So let it be respondent number 3.
Instead of 4, you say 3 in all the previous paras. So to be implemented as respondent number 3 in the such and such. Stop. This application is therefore allowed. Stop. The petitioner shall take steps to file an amended cause title implementing Srimati Sarita Yadav IS, Secretary to the Government of Nagaland, Department of Higher and Technical Education as respondent number 4 in respondent number 3 in COP number 21/2023. List after 1 week. You file within a week, amended cause title.
Okay.
For hearing, item number 27.
Beverage Lordship, my Lord, kindly allow me to place the status report, my Lord. My Lord, kindly allow me to state the brief status of the case, my Lord. My Lord, see, on 11/2/2025, this Honorable Court has granted anticipatory bail to the petitioner.
11/2/2025.
And thereafter, in that order, Honorable Court has directed the petitioner to appear on 25/2/2025. And he appeared, my Lord. He appeared and he was released on bail bond. Thereafter, for further investigation, and the IO issued notice on 2/6/2025 on 3 occasions. And the petitioner, he didn't appear. And thereafter, by Honorable Court, this status report was submitted before the Honorable Court, and by order dated 25/8/2025, the Honorable Court has directed the petitioner to appear on within 10 days. And on that day also, the petitioner has sought time on the ground of, on health ground, since they have produced the medical certificate and sought for time. However, court has given liberty to grant within 10 days through video conferencing mode or physical. And IO has tried to interrogate the petitioner through video conferencing, but due to some network problem, he could not. That is why, again, the Honorable Court on date 23/9/2025 again directed the petitioner to appear on 7/10/2025.
17/10.
Yes, and at 1 p.m.
7/10, okay.
But he didn't appear, my Lord. And thereafter, on 23/10/2025, again, the court has given liberty to appear on 30/10/2025 at 11:30 a.m. And petitioner, he didn't appear, my Lord. So, my Lord, here the petitioner is intentionally and deliberately misusing the liberty granted by the Honorable Court, my Lord. And the petitioner is not cooperating the investigation agency, my lord.
And that anticipatory bail petition is still pending.
No, already disposed.
It was
Disposed,
disposed,
yes.
Lordship. It was made absolute.
It was made absolute.
Yes,
Yes.
and he admitted his liability on that AP, Lordship.
So
And the present petition is for quashing of
Lordship,
that case.
Yes, criminal proceeding.
Lordship, he's still going under medical treatment, Lordship. So,
But
the IO and
if
the...
he's not cooperating, then how will the court quash?
Lordship, if I may be allowed to place this medical certificate and the WhatsApp messages between the IO and the petitioner, Lordship. They are in constant touch through this WhatsApp, Your Lordship. He is willing to appear through this VC mode also, Your Lordship, but he was advised by his doctor not to travel, Your Lordship, because he's having this disease of melena, Your Lordship. It's not like he's absconding from the IO, Lordship, case.
My lord, in the last occasion, the state has already given assurance that the state is ready to give security also, if the petitioner is cooperating. But in that assurance also, he is not complying, my lord.
Otherwise, are you filing any objections in the criminal petition? Are you filing objection?
No.
I'm appearing for the private respondent, my lady.
Are you going to file any
I've
objection?
already filed.
You filed?
Yes. My lady, this is a poor attempt of the petitioner to distract this honorable court. Ample opportunities has been given. Your ladyship is seized of the matter, but for your easy appreciation, 4 consecutive orders passed by this honorable court in favor of the petitioner. May I be allowed to submit for easy reference?
Now he's saying he's not well.
My lady, this is his case, and all of a sudden, medical documents after one another, I think that is very inappropriate, my lady.
Still, my lord, the petitioner is still in touch with the IO.
Respectfully, the petitioner is as healthy as a bull. He's a contractor by profession. He's been active in his profession. But when it comes to this matter, he's been dragging this matter, my lady. And most importantly, directives one after another has been passed by this honorable court, which has been deliberately discarded.
My lord, here the petitioner is saying that he is giving in touch with the IO. IO, when he called the petitioner, he never received the call. But only through SMS he replied. So through SMS, how can the IO can take statement or any interrogation? How can the IO can proceed with the SMS, my lord? Physical presence is very much required, my lord.
See, your ground is that you are saying that there is no criminal ingredient and that it is purely a civil matter. That is your main ground. But unless your statement is recorded properly, how will the IO know that it is a civil matter and that there is no criminal ingredient? And you are not appearing properly. No, that is the whole problem. Because the court also needs an updated CD where your statement is properly recorded. And on that basis, the court will come to a conclusion. But if you are not cooperating, then?
Lordship, he is ready to cooperate, Lordship, through
When?
VC, Lordship.
No, not VC. Through VC, I don't know whether it's actually...
Investigation through
because
VC is, that will mockery,
it's not possible, it's not very convenient. And this court is also ready to give the security also. In fact, on previous occasion, the court has already stated that security may be provided if you are willing to appear. Then what's
Because
the
of his
difficulty?
health issue, Lordship, he could not appear.
No. Now you give a date. You give a date when you can come. Physically.
My lady, my respectful submission would be, if this honorable court is willing to give one more last opportunity to the petitioner, cost may be imposed. At least 20,000. The authority of this honorable court cannot be undermined.
Lordship, on the next date, Lordship, then.
When?
Date 5,
When?
Lordship.
What?
5, Lordship.
5th December?
December 5, Lordship.
In the last occasion also, at their instance, this date was fixed, my lord, my lady.
Yes.
So my respectful submission is, give them the last opportunity, but at least cost may be imposed. At least 20,000, my lady.
On the next date, Lordship, if it doesn't appear before the IO.
This is his petition. He should be the one trying to get dispose of this petition. In fact, after securing interim protection, he's been playing all this, my lady, which is totally unacceptable.
Mr. Medovero. I've also heard Mr. Chupapong, learned public prosecutor for the state of Nagaland, and also Mr.
Kitokasu
for the informant / complainant. Stop. Para. When the matter is called, the learned PP has produced the latest status report from the IO of the case dated 18/11/2025, wherein it is stated that the last order of this court was
Friday
23/10.
Yes.
That in pursuance of order of this court dated 23/10/2025, the petitioner was to appear positively at 11:30 a.m. on 30/10/2025 before the investigating officer, but on 30/10/2025 the petitioner has again failed to appear before the IO. Stop. The IO has therefore prayed that the interim bail granted to the petitioner should be cancelled as he is not cooperating with the investigation. This court is of the view that in order to dispose of the present petition, the statement of the petitioner is required and the IO has to submit an updated status report only after obtaining the statement of the petitioner. However, the petitioner has failed to appear before the IO. Stop. Para. It is seen that this court has passed several orders, being order dated 29/8/2025, 23/9/2025, 13/10/2025, and 23/10/2025. Directing the petitioner to appear before the investigating officer. Stop. However, till date, the petitioner has failed to appear before the IO on one pretext or the other. Stop. which order was that? That security, to provide security and all?
23-10-2025.
No, not 23.
23.
Not 23.
1310. Provide security. 131025, my lady.
1310. No?
Yes.
In fact, by order dated 13-10-2025, this court had even directed the IO to provide necessary security to the petitioner, if at all required, so as to appear before the IO. Stop. It is observed that the petitioner has been evading the orders of this court, and therefore, as a last opportunity, the petitioner is directed to appear before the IO of the case physically you appear on 3rd, physically before the IO on 3rd December 2025 at 1 p.m. At 1 p.m. At 1 p.m. and the IO shall provide security if so required. However, it is made clear that if the petitioner fails to appear before the IO on the next date, cause shall be imposed on him. So, list the matter on if he appears on 3rd and 8th December.
Okay, my lord, your lordship may kindly add one sentence. If the petitioner fails to appear, then automatically that liberty granted to the petitioner will be vacated, my lord.
We'll see on the next date. Some orders may be passed.
Yes.
So, list matter on 8th December for consideration of the matter, for hearing the matter. Stop. Any other thing? To appear on such and such and record his statement. Put that also, and record his statement. And thereafter, list on 8th December, on which date the IO shall submit the updated report.
Much obliged.
Much obliged, Lordship.
Hello. Awe, Pugo, Tushi, Molo, Vincing.